TNLU, and it's pleasure to welcome you to the enlightful session on clinical research in law and justice administration. Today, we are fortunate to have a distinguished expert, Dr. Aman Hingorani, with us. Sir holds degree of LLB from Campus of Law, Delhi University, and LLM from School of Law, Warwick University, United Kingdom. He has awarded PhD from Delhi University. Dr. Aman is a lawyer and mediator in Supreme Court of India and High Court of Delhi. Dr. Hingorani has also acted as an arbitrator. He is an author and he has been engaged in teaching since 1998 as visiting faculty. As an expert in the area of clinical education, I welcome you to serve to share your thoughts and wisdom and also inspire the participants with your expertise and experience. Thank you, sir.
Before Sarvitek, Dr. Aman Hingorani, I have long association with Dr. Hingorani, Advocate Supreme Court of India. How many of you are aware about the annual law, ASIL? Annual Service of India Law. There is one topic that is public interest litigation. Have you ever read that? That is the authored by Professor Hingorani. We are honored and privileged to have it. It's having practical experience in mediation program also from Supreme Court. While I was in the Indian Institute, sir was one of my faculty, visiting faculty for the diploma courses we are having in the evening. So, sir, welcome to you in an admission.
Thank you, Professor Jaiswal. Thank you. Am I loud enough otherwise?
Yes, sir.
That's okay. Cool. Thank you for the generous introduction. I'm in law teaching by accident. I'm actually a lawyer. Started my practice in 1992, and practice is disillusions you to such a degree that I managed to do my doctorate side by side. And then I started teaching. And I've taught at Delhi University right from 1998 or 17, and stopped perhaps longer than most of the ad hoc lecturers. And apart from that, in different universities, different MLUs, and institutions both in India and abroad. So what I would like to talk about when I was asked to come and speak out here, I've seen your material. I mean, it's quite detailed and academic, etc. What I was asked to do, and I was just discussing before I came here, that what should I really talk about? Because when you're talking about clinical research, clinical legal education, the area is huge. So what should I really be talking about? And you have a very distinguished lineup of people from the academia or community. So the idea was I should speak to you more about the practical aspect, or the I assume you all teach law, and most of you teach law. If you're teaching law, particularly a CLE paper, how do you go about doing it? What are the challenges? What are the teaching methods? How can we innovate? To see from this particular session, can you take back something that you can put to use in your own teaching as profession? So I would like to make it interactive. Of course, I'll share my thoughts, but I would like to know from all of you what you teach. You teach CLE papers. Bar Council says teach even substantive law papers in the CLE method. Now, how do you do that? How do you teach administrative law, constitutional law in a CLE method? So, what do they mean by that? So, I would like to have your. I'd like to understand what's the current practice, because, like I said, I'm not a full-time into law teaching. I did teach substantive law subjects for almost 2 decades, alongside CLE courses. But now I teach mainly CLE courses of whether it's advocacy, mediation, uh, client interviewing, negotiations, and so on and so forth. So, floor is yours. Introduce yourself. I know you know each other because you've been here for some time, but I don't know you. So just introduce yourself and share what is the kind of course you teach and what is the teaching method you use. So that's something I'm more interested in. Anyone?
So I'm Dr. C. Tilaganandan. So I was in Government Law College, and afterwards now I'm working at Nehru Academy of Law. I'm the principal there.
Okay. So what's the teaching method you use?
So generally we use lecture method, and along with that for some papers like mediation and all those things, we do that clinical method, and that is
So that would be role plays.
role play,
Class simulation exercises.
simulation exercises, etc.
Okay.
And for this Panchayati Raj, so we have local self-government paper, and for which we conduct surveys, go to the panchayats
Okay.
and conduct surveys, and such kind of activities we do. And while I was in Calicut, we conducted a lot of such programs. But here, so I just started.
So it's a mix of lectures with class simulation exercises, field trips, and perhaps internships.
And also we visited tribal areas and to sensitize the students how those people live, and we also conducted surveys there and to understand the problems of the people and prepared reports, such things.
Okay.
Good morning, sir. So I don't have teaching experience. I'm PhD scholar at HPNLU. I have completed my master's in 2023 and enrolled in PhD at the same time.
Okay, so we can open this session for those who have had teaching experiences. So, Madam, yeah.
Well, good morning, sir. I'm Dr. Dilsha Sheikh. I'm Professor and Dean, School of Law, Satyabama Institute of Science and Technology. Being a person who drafted the curriculum as a team for School of Law, and clinical papers are mandatory, wherein we switch over to different kind of teaching pedagogy. We really make students to learn by experiential teaching and learning method, actually. Since ours is a multidisciplinary university, our students got an opportunity of utilizing the resources, like our university has adopted 6 villages, wherein we conduct legal awareness programs, and also like our students get an opportunity of getting associated with NGOs, to be specific with relating to arbitration, conciliation and mediation. We got into MOUs with mediation agencies. Like we entered into MOU with, for example, KFCRI, which is one of the international mediation agency that is working on floor very well, and there are many more agencies with whom we are coordinating, and we conduct competitions, national mediation competitions. We have conducted a couple of it, and also like students have been given an opportunity to conduct, being part of simulation exercises, the mediation, arbitration even.
Who conducts, who supervises the simulation exercises?
The simulation exercises, the people have been invited from the consultancies, mediation consultancies, and they'll be guiding our students. And also like we offer internships for our students to the mediation agencies, wherein they really get an opportunity to observe the mediation process. We are not limiting ourselves to the floor level kind of thing. International corporate mediation also our students got an exposure, and there have been interns in many of the mediation agencies. This is how we are working, and of course it is really benefiting our students before they being completed their programs. They are becoming these days like industry ready in a way. Wherein like they are not directly only focusing on after AIB exam just getting enrolled and then becoming an advocate or going as a junior for a long time. All these are giving an opportunity for our students to really explore themselves, the kind of opportunities what they are getting these days. So thank you.
And the internships, at which stage are they structured? Right from the first year, or
It is from second year, sir. Actually, like as per BCI, the 5-year student need to get 20 weeks internship. But the point is like these days the students are really fortunate to have even online internships also as well. So apart from regular internships, students are really exploring the field of mediation by getting in touch with the agencies. Sir. Thank you.
anybody else who been teaching?
Good morning, sir. My name is Avni. I'm teaching criminology students at the Jindal Global University, and I have almost 8 years of experience before joining Jindal. I joined recently only in January, and so what I teach, like how I teach, is with the experience. Whatever field experience I've got, so I try to translate that into my classroom teaching. And secondly, also we organize a lot of field visits.
When you say field experience, you were practicing before that?
No. I was working with the government. I mean, Ministry of Home Affairs.
So it's the government experience you're sharing with the students?
Yeah, because I mean, I was assistant in Supreme Court Committee on Prison Reforms. So through that, like I've got a lot of exposure in the field, and before that, I was working with the Ministry of Women and Child Development also for 3 years. So I translate all that experience to my students, as well as we also organize a lot of field trips. We go to the prisons and juvenile institutions, and we also have clinical courses running at Jindal. And for me to also migrate as a clinical faculty, I need at least a year's experience. So that's what I'm also planning to transition into.
Anyone else?
I teach research method at Shimla, and in research method, I try to bring more participative approach to the idea of research method. So, Socratic dialogue, for example, is an appropriate way to stimulate the students' experiences with respect to research, and also I try to give them a lesson about participative research and participant observations. There is a paper in ILI published by Walter Fernandez which suggests that research should be more participative in nature rather than simply observing from outside. So that approach, I think,
When you
is.
say participative in nature, what do you make them do?
Yes, so for example, in anthropology or ethnographical studies, researchers are first of all familiarized with that respondent groups, and thereafter they can share experience, they can help each other, and by that doing activity, they can learn.
But is this empirical research?
Yeah, it's empirical.
Research. Anyone else? Yeah, somebody with that.
Good morning, sir. I'm Dr. Ajay Singh, advocate for Jamindrina High Court and visiting professor at Mediator University. So I was in full-time teaching from January 2016 to December 2022. I resigned from my job last year and I started my practice. So then last semester I joined as a visiting professor. So I taught client counseling, and in client counseling I used to tell the students the do's and don'ts of the legal profession. Although I've just had 1 year of experience in the as an advocate. But I think it is imperative in order to teach technical subjects, and even procedural law subjects. A teacher must have some sort of practical experience. Without practical experience, you can't teach the procedural laws and the clinical subjects effectively. Like that's how I think. Although the opinions of others they may be different. So in client counseling, I used to make the students role play. Like some students were acting as clients, some as advocates, and I used to give them some problems to solve, like a moot proposition, and then I asked the students to to act as advocates and clients. So that's how I was dealing with client counseling, and in the coming semester, I'll be taking up practical aspects of criminal litigation.
Anyone else?
So I'm Ruchika Naik, I'm assistant professor at Goa University. My usual teaching method is a Socratic method where I back and forth talk to the students, and this is because I can't do lecture method because they start looking like rag dolls to me after some time. So I prefer some sort of interaction with my students. And apart from that, if we look into the previous college I was teaching at, that is B.M. Sarvankar College of Law, it's an affiliated college with Goa University. In that college, we actually have 32 permanent legal aid cells, which are set up in the entire state of Goa. These are permanent legal aid cells where we have put students according to their feasibility and around the area they stay in, and they provide paralegal services such as making senior citizen cards or Krishi cards or certain cards like that, or even help the people who cannot afford legal aid to legal services, and give them certain help with regards to that. So we are actually at Sargawkar College, at least we are very much into the field related work. So that's it, sir. Thank you.
Well, I mean, I find that I find it very useful, and I'm sure those who are not teaching or teaching different method will also learn from the variety of teaching methods we've spoken about here. But I have a basic issue with all these methods. You see, what is the law school meant to do? A law school is meant to produce not just law graduates but lawyers. They need forensic skills, the professional skills. Lecture method is this attention span of a student is so short that if they can get something on Google, they're not bothered listening to you. They will sit in the back row and they'll just pick up their laptop and they'll be chatting or doing something else. It's a waste of time, waste of everybody's time. As far as teachers are concerned, though there are a lot of teachers, of course, the senior teachers have learned on the job. We don't really have any training on how to go around teaching in this country. At least not a systematic training before you join the teaching profession. Those you do finish LLM, clear net, clear whatever you need to clear, find a place, start teaching, and you're only one class ahead of the student. So students ask something which will come later on the course. The teacher may not know himself or herself what that topic is or what is the law at that point. The basic teaching methods which you mentioned is lecture method, class simulation exercises supervised by people from outside, for instance, the professionals, etc. Legal aid clinics, field trips, moot courts would be one. I'm sure some universities have mock trials. And then internships with NGOs or going to adopting villages, etc. All these are not adequate to equip the students with the skills required. There are many more modern teaching methods which have been there in many jurisdictions, which we have adopted in various universities in India over the last 30 years. So what I'll try to do is I'll share with you some of those teaching methods, and with the hope that strands of that can be borrowed by you in your own teaching practices. So to start with, we need to identify what are the skills that the student should have, which means these are the skills you as teachers should have. You cannot transfer skills to students if you yourselves don't have those skills. As was pointed out by our lawyer friend, that you need to bring a bit of code into the classroom. And that's a handicap for most of the teachers who've never seen the inside of a court. They've never had that exposure. So that link is not there between the bar and the universities. And that's why they are at a disadvantage. Teachers are at a disadvantage. They themselves do not have the confidence to get up and tell students this is the right way of doing it or wrong way of doing it. They themselves have never done it and they haven't seen anybody else do it. So that's the reason why the courses which are there, which are meant for teachers, try to create a court environment within the classroom, try to transfer into the teaching, when we do TOTs, transfer to the teachers the skills that lawyers possess. It can be done. One may be a born orator or a poet or a painter, but skills is something that can be acquired if taught in a scientific manner. We're not on substantive law. That is something all of you would be very well versed with. We are not on procedural law. Those who teach CPC, CRPC, Evidence Act are familiar with that. We are on the performance skills or professional skills. That is different from this. That is putting, you need the skills to apply your substantive and procedural law. I read somewhere some article on which is written on PhDs that there was advice, don't do a PhD that does not have a practical application. There's no point simply doing things for the sake of it. There must be some purpose behind it, some use to it. So you might have the substantive knowledge or the procedural knowledge, but that needs to be put to practical application by the student once you transfer that knowledge to the student. So for that reason, you need yourself to acquire that professional skills, those professional skills. Now, what are those skills which the students should eventually have, which have to be transmitted by the law schools? Now, lawyers don't only practice in court. We have a range of activities, legal, and maybe strictly not legal. Mediation, we talked about. Mediation is a practice of law, but it is not only a practice of law. You have a lot of psychological assessment done out there. We will discuss about that in a bit, but the different kind of skills which at least lawyer must possess with Section 89 of the CPC. A lawyer can be asked to perform different roles. One is, of course, within the court. That's the adversarial system. So the lawyer in the adversarial system, whether in the court or in arbitration, must be able to analyze the case, identify the facts in favor of the client or against his client, or to deal with the bad facts, to how to master the law on that point, to research, to be able to make what we call a case theory or case concept, that is the plot line of a particular case, right from the time of drafting till the time of argument. So a lawyer must be able to do a case analysis, formulate a case theory, and their parameters. I can expand upon this as much as we have time later on, but just to give an overview of the nature of skills. The lawyer must be able to, should be able to handle witnesses, examination chief, cross-examination, and so on and so forth. The lawyer should be able to structure arguments, present arguments. Moot courts are a good example of how not to argue a case. We make everybody unlearn what they learn in law schools. But nobody argues the case that way in court. Nobody tells the court, gets up and tells the court, this court is jurisdiction. Obviously, that's why you're there. Nobody tells the court that this happened in this case, this happened in that case. It's not an academic exercise. You win cases on facts, not on law. So you need to be clear to the point, get your relief, sit down. So how to structure an interim argument, a final argument, appellate argument, a trial court or high court or Supreme Court. All the skills should be there with that lawyer. Of course, these advocacy skills are based on the communication and client interviewing skills to gather full information. It's a good lawyer is one who can protect the interest of his client without having to blame anybody, without even having to go to court. A lawyer can do that only if he or she is able to gather full information from the client. That is information regarding what the client wants, the client's priorities, his or her interest, how he wants his or her interests addressed. In the process, the lawyer must have communication skills to overcome communication inhibitors. The lawyer or client may not be willing to tell everything to the lawyer. There could be an ego threat. What if the lawyer thinks of less of me? There could be a case threat. What if he thinks I have a bad case? There may be painful history. I don't want to relive this traumatic experience. There will be many inhibitors. The role of the lawyer is to overcome these inhibitors, to get full information, to be able to tell the client these are your range of options, legal and non-legal, whether it's litigation or mediation, negotiations, counseling. It is for the client to choose, take an informed decision after the lawyer explained all the options. So that's your base. Superimposed on them are your advocacy skills, case analysis, witness handling, structuring arguments, drafting, legal drafting. Pleadings, the way we teach, is not the way we draft in court. Most of those formats are outdated. Even in the formats which are there, you'll have only a template or structure which is provided. But the presentation of facts is dependent on the case theory. That's what drives the entire case. And that has to be done by the lawyer once they, before they get into, immediately after they get the information, the lawyer is supposed to make the pleadings. Pleadings is a performance skill, and they're teaching methods how you can draft a document containing a legal element without having taken recourse to any book. This is a performance skill. It's not procedural or substantive law. These are some of the skills I'm talking about without being exhaustive. The minute a lawyer is supposed to be a negotiator, there are another set of skills. Consensual approach, where can a lawyer satisfy the interest of without compromising the interest of your own side, can he also satisfy the interest of the other side? So that is a settlement. Now, what are those skills? Negotiation strategies, bargaining techniques. All that is something that the student must know and must internalize. Mediation. Mediation basically is a third party facilitating a settlement or assisting two parties into a negotiated settlement. So they're facilitative skills. So you'll have communication skills, superimposed on them there will be negotiation skills, superimposed on them there will be facilitative skills, superimposed on them that will be social skills. Now with online mediation, technological skills, with smart contracts, artificial intelligence, you have mediation has a huge scope. And for that, the mediator must know what is artificial intelligence, what is blockchain technology, how do you code in a settlement agreement to have automated enforcement of settlement agreements. There's a huge area out there. The skills must be taught to the students. You move on to a permutation of these MEDAV, etc., and so on and so forth. This is just to give you a flavor of the kind of skills you need, or the students need, which means these are the kind of skills that the teacher or the faculties should be able to provide to the students. We go on the premise that students absorb about 30% of what they hear. They absorb about 60% when they see somebody do it. They absorb maximum almost 90% when they do it themselves. And hence, learning by doing sessions, simulation exercises. That has been one part of what we already mentioned, is one of the teaching method, but it is only a half-baked teaching method, because that particular teaching method will never be effective unless the student is given a feedback there and then on that particular performance. Modern teaching methods require faculties to demonstrate. Before every exercise, a faculty must get up and demonstrate that this is the way this ought to be done. If there's an argument and I'm teaching, I'll get up and do an argument for the students as though they are the judges and I'm a lawyer arguing for them. Before I ask them to do the argument. Once is a performance, and I'll just giving these by way of illustrations because it's a broader area. But let's take advocacy skills. Let us take a cross examination. And one of the principles under the Evidence Act is, and also the principles of prudence is, never ask a non-leading question to a witness in cross examination. Non-leading question is giving a platform to the witness. Questions with who, what, where, why, how. So the witness can say whatever they want to say, and cross is the other side's witness. So what we normally would do, just to give you an instance, is we have course materials just circulated in advance, hypotheticals, witness statements. Students are required to read them. It's a pre-read, something our students don't do. They don't have the discipline, but they're supposed to read and come. One student will be a witness, one student will be the lawyer. The student is asked to do a cross of that witness. That faculty, if I'm the faculty, I'll be sitting taking on my notes. For about 6 minutes, I'll let that person perform. Then I'll stop that student, I'll go stand next to the student, and I'll give a extempo feedback or review, as you call it, within 2 minutes on that performance. And that review would be a structured review. One area of concern, headline as you call it, because students can't take back more than 1 point at a time. From my notes, I'll give a playback as to this is what you have done. I'll tell the student the reason why it ought not to be done. You're giving a platform to the witness or the other side to say whatever they want to say, to paint your plan black, to put forth their case theory. I'll give the remedy, how to fix it, how to use 3 C's, or basically how to cut out the escape routes of the witness, and ask only leading questions that so the witness is bound to say yes or no. I'll stand next to the student and I'll do an extempo demonstration illustrating that remedy. And I'll ask the student to do a replay. Have a second go. That performance in many jurisdictions, particularly in Oxford, where I've taught British barristers on this particular method, but also within India, where we have taught Indian students, whether it is in NLU Mumbai, NLU Delhi, in several other institutions, where we have taught them on this method, we also video record that performance. The student takes a pen drive, goes to another room where another faculty gives a video review on stylist issues, body language, eye contact, waving of hand, shifting, demeanor, tone. Point is, every student is given a feedback there and then. And that student is a part of a bigger group of say 8 to 10 or 15 students. A different headline is given to each of the different 15 students. So the do's and don'ts are taught in that method as opposed to lectures. The same technique can be adopted for mediation. The group, you have a role play, I'm sure you do those role plays, one mediator, 2 parties. Mediator starts with the opening statement, invites the parties to share their perspectives, keep shifting between joint and private sessions, to get the parties to shift from the stand they've taken to the underlying interest. So that is a settlement between the parties. That is video recorded. It's very simple. Just put a standee, put a mobile on it, that records it. Take that mobile, put it with the cable onto the laptop, and you can see the whole performance. One role play or 1 hour would invite 2 hours of feedback. Feedback, one by the parties to the mediator, feedback by the faculty in the class who's observed the mediation, feedback to video review. The idea is to transfer skills. And this is skill building, is cumulative skill building, one skill built on the other. The students need to do it. Just like watching somebody fly a plane, you don't become a pilot. They need to do it themselves. So if you have that kind of teaching method of faculty demonstrations, students performing structured feedback, in mediation, settlement exercises. I mean, just a month ago, we did a national workshop, first national workshop in NLU Bhopal, which was a drafting competition, on a model honor exercise given after the students were taken through the entire course of advocacy skills. Similarly, for mediation, you can do drafting a settlement agreement is a performance skill. It's going to be executable as low as the degree of a court. So it's to be specific, executable, enforceable, unambiguous, with no blame assessment, positive language, who will do what, in how much time, in what manner, for how long. All the things need to be reflected in the settlement agreement. If the student or the lawyer or the mediator has to draft it, they have to be taught as a performance skill, not as substantive or procedural or subjective. So the point I'm going to make is that we have teaching methods which have been using, they have been put in place by people who are in the academia. Professors, no matter how distinguished, don't have a clue of what happens in court. Advocacy, performance skills, I mean, you have, for example, let's see some of the methods you've had, which you talked about right now also. You talked about lecture methods, you're putting people to sleep. They can read it themselves. You don't need to have a lecture. If at all you need to teach substantive law subjects, what prevents you from dividing those students, and I'm sure some of you might be doing it, dividing students into groups, making them make presentations for or against in a given situation, but the skill of the faculty is not to get people to perform on a decided case. The skill of the faculty is to use the decided case, but put variables to build it like a hypothetical, to see whether with one variable would the outcome have been different. When we teach constitutional law, we don't teach this happened in A.K. Gopalan, this happened in Maneka Gandhi, this happened in Kishan Bharati. We teach the development of constitutional law from different cases. So you don't need to spend 1 hour giving a lecture on one case, the case method. There's no purpose of doing that. So when you're talking about class lectures, it can be made interesting, it can be made innovative, by students being asked to make presentations. And when I talked about the structure of arguments, that will be the structure of arguments, would be the structure of presentations. So that I can expand upon this at a later stage as to what are the kind of structures of presentation that ought to be there. When you're talking about internships or about role plays, how many students get an individualized structured feedback or just a general discussion? When we talk about internships, there's no point sending students for internships unless they know what to spot. Otherwise, it's a glorified clerkship. All they make to do is take out research on some mundane proposition or carry files. What for? When I started teaching in 98, the first year, first term, I got students bringing the court diary saying, went to so-and-so court, case name, judge name, what happened, case adjourned. That was the pattern. That's not the purpose of case diary. So I started insisting that when you go to the court, you observe what's happening. After you write all, just to ensure that you did go to court, you give all those details. But after that, I want one para on a performance skill you have observed in court. You have lawyers performing for you free of charge. observe them. Is somebody asking leading questions, examination chief? Is somebody asking non-leading in clause? Are they asking compound questions requiring the lawyer to refrain from one questions? Are they try to elicit more than one fact at a time? So the witness can say yes, no, yes, and then the lawyer is forced to rephrase the question, giving thinking time to the witness. So that's something we shouldn't be doing. So did the lawyer ask compound questions? Did the lawyer do a confrontation without cutting out the escape routes? And so on and so forth. Or was the lawyer arguing with the witness? Was he threatening the witness? Good advocacy is to take the witness up the garden path, get what you want, and then put the knife in. Not shout at the witness. So there are many techniques by which all this thing is done. Use a prior inconsistent statement and so on and so forth. Did the lawyer do all this? Put that in your court diary. When you're observing arguments, did the lawyer formulate the question to be considered before narrating the facts? Or did he mix up facts and submissions? Did he introduce the case law properly? There's a way of introducing case law. You don't read in court. So I seek to refer to this judgment, which is the authority for this proposition. If I can take the quote to so-and-so page, read out the one line. So applying this proposition to the facts of this case, this is the result. So it is a way of introducing case law, it is a way of introducing evidence. Did the lawyer do that? Or was he just reading? Those inputs of the students have to be there in the court diary. That's the purpose of going to the court. Not to go there and say, okay, it's adjourned. Similarly, when lawyers are sent to students are sent to a chamber, what did they sit through the client interview? Did they see how the lawyer managed to overcome communication inhibitors? Did he give an option? Did he force the client to take a decision on whether to file a case or not? Was it an informed decision? Was he sympathetic enough? Was there enough empathy? Or was the lawyer on the phone when the client is sitting, trying to talk to him? There's so many aspects, and all this it becomes useful for the point of view of assessment. In a traditional method, how do we assess? Even for practical training papers, you have theoretical lectures, 50 marks theory, 50 marks of Viva, etc. Why? It's a practical training course. Assessment has to be based on the improvement between two successive performances. Some people may not be good in English. Let them speak in vernacular. But did they perform well between two successive? Was there improvement between two performances? If yes, he or she gets the marks. Which means every student must have a log diary to mark the progress of the student from the first exercise till the last. It's a completely different way of teaching students, assessing students. It is only then that you can even hope. Again, we're going to be talking about field trips. Or field trips, legal aid, etc. are very good to sensitize the students as to this is the problems faced in our society and to create that feeling of wanting to do social work, etc. But a law student, if he is not, goes around giving half-baked advice in legal aid clinics, it can be more damaging to the client. You cannot let law students lose on people in legal aid clinics. That doesn't serve any purpose. I mean, I can give you the instance of how we use, it's not a legal aid clinic, but how we use the same principle in a program I'm associated with in Cardiff University, where we have something called the Innocence Project. So, if there is a gross miscarriage of justice in a given case, the students are expected, it's a choice, but they, in a group, pick up that particular case, go to the court, get a copy out of the proceedings, interview the accused who may be in jail, etc. Go through the whole brief under the supervision of a faculty. And then the law students are in under their system in the UK can even talk directly to the barrister involved to say, well, these are the points which seem to have been missed or which have escaped consideration by the court below. So in an appeal, can we make this point? So you're integrating the students into the formal legal system. Students not giving legal advice to the accused, which may be half-baked. At best, they're taking out the research of, they're putting together their findings and bringing it to the notice of the lawyer who's appearing in that case, to assist that lawyer, but under the guidance and supervision of a faculty. So this is a program which has been going on for some years. In India, we're never short of cases of miscarriage of justice. There's plenty of material there for students to work on. If somebody wants to take that up. So I, for one, am not in the favor of legal aid clinics in the form in which they function right now. Everything has advantage. So even moot courts has advantage of letting people speak in public, okay, but then they can do that by other ways. But moot courts, like I said, the way the arguments are structured, I mean, what the moot court is an academic thesis on a particular proposition. So you tell the court, you narrate the facts. Facts can never be the same for both sides. Facts, each person, when they formulate the case theory, they stitch the facts in such a manner to give it a slant, to justify the inference they want to draw. The issues can never be the same for both sides. So we teach students to have the same facts, same issues, go around hunting for the law, and so the student does that exercise, and the student will then divide it between partners in the team. We teach lawyers, when the judge asks a question, answer the judge there and then. The judge will have a mental block, judge will not move forward till the judge has the answer. But in moot court, the students are told, well, if this is on that subject somebody else is talking about, tell the judge, my friend, my co-counsel will deal with it. We're teaching wrong advocacy. We don't read in court. If the judge is asking a question and we're not reading code, we don't have our notes, what will we do? We just have bullet points. Big font, 18, 19, 20 catchwords. Look at that catchword and speak. If a judge is saying something, put a pencil mark here, you know where to stop. Answer the judge, come back to that point where you put the pencil mark, continue your arguments. But there's a structure of an argument. Who you're appearing for, what is the purpose of listing, what is the question to be considered, the narration of facts, a complete narration of facts, submissions using your good facts, your case law, the evidence on record, and the case law issue-wise. So if there are 5 issues, after narrating facts, coming to my issue number 1, repeat that issue. Use your facts, evidence, law to make that submission. Coming to issue number 2, this was the issue. Facts, law, the evidence, law. And then the relief you're seeking. There's a structure to be followed. Not a memorial where a person, the students won't sit down till they won't feel satisfied till they've vomited everything out, whatever they've read. If they say everything out, they won't feel satisfied. So all that needs to change because the attention span of a judge is 1 minute, 2 minutes. You need to engage the judge. It's a conversation with the court to persuade the court to give you relief. So moot courts, the way they structured is wrong. Moot courts, and the fact that nobody gives you feedback on a moot court. One of the teaching methods was competitions. How many judges, whether in a moot competition or a mediation competition, will give feedback? Incidentally, the Asia Pacific Moot, which is organized by the Australian Dispute Centre in Sydney, they require feedback to be given by the judges in the format which I talked about. one area of concern, wife's area of concern, reason, remedy. So many other jurisdictions are adopting this. But in India, we're just having these competitions where the judges simply give marks wherever they want to. The students haven't learned from the process. So that again is, in my view, there's moot courts or mediations competitions are not a very effective way. And on the contrary, I remember in the year 2005, I was at Symbiosis Pune. They had a conference on clinical legal education. And what I had figured out at that time was that there is no consensus in the country as to what should be the content of clinical legal education. What should be the subject matters, what should be the teaching methods, etc. In fact, there was one poor professor, I remember, he said, there are one faculty, there are 180 students, we have one moot court problem. I can hear the arguments in my sleep. I've heard the arguments so many times. The 180 students are one problem. Why do we do these exercises? So, so that is as far as your moot courts are concerned. Which takes me also, there's moot courts and competitions, which takes me to the issue when you talk about working with field trips, NGOs, etc. Again, for what purpose? 5-year law course, the first year is initiating year, they probably say 2 internships with NGOs, etc. The higher you go, the longer you're on the course, start doing mandatory internships with different lawyers and so on and so forth. Advocacy skills you don't teach, that's yet another matter. We have had very, in NLUs, write themselves to say that we are we're superior in many ways in other universities. Not a single NLU in this country has a course on advocacy skills training. Think about it. A law school which is supposed to produce lawyers does not have an advocacy skills training course. The reason being that the people who founded these NLUs did not know there's something called performance skills. They confused that with procedural law. So if you have PIL advocacy, for example, National Law University, Bangalore, that talks about how to file a PIL. They're confusing advocacy with procedural law, not performance skills. The way of going about it, we have taught, at least in many universities, NLUs, is that we try to introduce advocacy skills as part of the evidence course, as an extension of that. But that is much later in your semester, maybe 4th year or 5th year. Internships start from the 1st year. Till the time they've done that advocacy course in the 4th year or 5th year, those internships are waste. You do have a program on ADR, on mediation, etc. But again, that is later. So some of the universities have inverted that, saying that since mediation, anybody can be a mediator, and you're actually trying to persuade parties to get them to settle. You're assisting their negotiation. So communication skills, time interviewing, negotiation, mediation can be taught upfront. And so when you have when you talk about internships, they could perhaps use that avenue initially. After teaching evidence act, send them to courts. So some universities have done that. But I think again, it's not you need to have the flexibility in every university. The academic council has to agree, or whatever it is, to restructure the course. Another proposal which had come in some universities, and they are still actually working on it, is that since mediation is a confidential process, you can't, as a matter of right, say I'll go and sit and observe a mediation. And so, why do not the universities open their own mediation centers on the campus, which is run by students, under supervision of a faculty so that the students can do internship on the campus as opposed to trying to find somewhere where they can do mediation. So that is, some universities are, it's already in the pipeline, some universities are working on it. The importance of this is that when you talk about moot courts or mediations, and you mentioned that you have people who are consultancies or consultants in mediation, they are the ones who judge. A good mediator may not be a good teacher, or vice versa. Even if you're talking about clinical legal education courses in the universities and you call lawyers or reputed lawyers good practice, they have a name, they may be good lawyers, but they may not be good teachers. So, which is the reason why I've always suggested that every university has to invest in the faculty to equip them with these skills so that there's an in-house faculty running the CLE programs. The counterpoint to that by the management seems to be that the attrition rate is very high. The faculty will learn the skills and leave the university, and the investment will be wasted. Because after every few years, there might be a change of the faculty. But some solution needs to be found there. You can't leave assessment or judging or even feedback to students in the hands of people who may or may not be good teachers. There has to be a particular standard. And we don't teach any of this with reference to our own experiences. If I'm teaching advocacy, I'll be teaching on those hypotheticals, giving the structured feedback, other faculties giving other kind of feedback, right from the stage of case analysis to drafting. I won't be discussing my cases. When I'm teaching mediation, I'll be talking about conflict, how to handle conflict, genesis of conflict, how to be able to break the conflict cycle by getting into the mind of a party to understand why that party is thinking in a particular way, how to decondition that party. There's a lot of behavioral sciences involved there. How to separate the person from the problem. How to get the parties to see different ways or different alternatives to resolving that problem. What is the way of handling emotions? How to do restorative justice practices in mediation. There are different things I'll be doing, but I won't be sitting there and saying, well, I did this case, I had this mediation before the Supreme Court Mediation Center, and this is the way I resolved it. Personal anecdotes or experiences do not assist students. They need to be able to learn from a standardized program, standardized course material, through in a scientific structured manner. And that cannot be dependent on who's the faculty. Faculties come and go. So, so each of the points which you have mentioned, while of course we have been doing with these in one form or the other, one shape or the other, for a very long time, but it's high time we need to reinvent ourselves if we really do want to have students who are not either exploited or who feel inadequate or who feel that they, being a first generation lawyer, they need crutches to walk on. Nothing in law, there's nothing in law that cannot be taught in the university. Everything can be taught in the university. Two teachers who've never seen the inside of a court. It's a question of building that in, because in this country, the bar councils don't have the statutory powers to do practical training courses that have been struck down by the Supreme Court in the past. Universities just produce law graduates. So there's a gap between law graduates and becoming lawyers, and nobody to teach it. There's that vacuum. So that's where the faculties have to come in. And they need to acquire the skills themselves, and then in a systematic, scientific way, transfer those skills to the students. And this would hold true not necessarily only for papers like on mediation or advocacy. Could be held true for any kind of paper, whether it's constitutional law, whether it is IPR, whether the different ways, innovative ways of teaching that. Keeping a track of the time, it's already 11:05. We can take a break. You have question. We can just collapse both sessions so that we can also finish off early if we run out of questions. So, but this is one side of it. There are many other aspects about how to go about acquiring those kind of skills. In order we can have a discussion on that. But any questions? Anything you'd like to share?
Sir, on one point which I found a difference of opinion amongst the advocates when I decided to start my practice. So I consulted a few senior advocates on the point that whether I should start my practice from the district courts, I should spend 1 to 2 years in the district court and then move to the high court. So some of them they were of the opinion that yes, you should spend at least a year in the district court before moving to the high court. But then ultimately, the senior whose chamber I joined, he said that you can, if you are determined to become a high court lawyer, then you can start from the high court itself. So, sir, like many students of mine asked me the same question. So, what is your take on this?
You see, I practice right from trial court. I do witness handling and everything to arguing before the Constitution bench in the Supreme Court. So I don't think one needs to confine themselves to any given court. The nature of practice is different of trial court, high court, Supreme Court, but the lawyer should have the mental adaptability to adjust to every kind of practice. So that is one. But that is a trend which I've seen in many law schools where students are encouraged to choose areas of the specialization or decide at least on the area of specialization in the final years that which side you want to go. And I think that's a horrible idea. Law is multidisciplinary. Even within the fields of law, we don't see laws. I mean, it's only for a curriculum or subjects you divide them in different. You divide them in different subjects in way that they overlap. I remember a case. This was way back in the year 2000, where there was this British girl, which was about 24, 25-year-old, who was in the RJ on charges of trying to import cocaine into India. The cocaine from Colombia, she put cocaine in a postal parcel and sent it to GPO Delhi, and that has been seized at Frankfurt Airport. They found its cocaine, so they had a controlled delivery to see who the consignee is. So the Lufthansa pilots brought it to India, gave it to the NCP officers, who laid a trap for her at the post office. So when she went there to collect the parcel, they said, give us a letter saying it's your parcel. So the handwriting on the letter matched the address, the handwriting on the parcel. Then she took the parcel, went to Parliament, to her guest house, opened it, and she was caught red-handed. So she was already in jail for 4 years. She had been told by the trial court judge that your sentence is between 10 to 20 years. So the High Commissions had requested me to look into it. I've managed to get her out in 6 months on a simple proposition that at that point of time there was a bill pending in Parliament to make the possession of drugs which are the subject matter of an offence in another country also an offence. It was not yet an offence. But here the drugs were seized in Frankfurt. Offence finished there. It became the subject matter of the offence in that country. Possession of those kind of drugs was not yet an offence. So Article 20 came in. The point is, for NDPS matter, I didn't bother going to see whether it was a seizure properly, was Section 50 complied with, was no tampering of the samples, was the FSL report exhibited. I didn't need to. I relied on constitutional law. The point is, when we understand law, you can't pigeonhole fields of law. Of course, some areas are specialized like IPR, competition, so on and so forth. But those choices should happen much later in life, not in law school. In law school, every student should be familiar with every branch of law. They are too young to know what would actually excite them once they're in the profession. Once they join the profession, they may not like litigation because it means waiting the entire day, morning to evening, your case will never reach. Some lawyers, some students may say, well, I enjoy mediation, I find it far more emotionally satisfying to rebuild relationships than the adversarial mode of fighting of negativity all the time. Some may say, we want to go into teaching, some might want to go into judiciary. These decisions are taken in the first 1 to 2 years of practice. It is after that those who choose to remain in practice will want to specialize in environment law or IPR or whatever. They can go in that direction. But the basic grounding of law of all fields, and when I say in all fields, it's not necessarily subject-wise, it's also substantive part, procedural, and performance skills. The lawyer should be able to perform and handle every kind of case, whatever case comes to the lawyer, handle every kind of case in any court in the country. And after some years, then take a call on what I really want to do. Any other questions? So should we take a break?
So recently, I see many students who are participating in moot courts are not taking classes very seriously, and many of them are trying to apply academic leave to go for moot court practices. But what we find that theoretically they are very poor, but skill-wise they are trying to argue their cases. In that way, their focus is more on a style than the content, and the content is lost somehow. So that's a big challenge what we find as a teacher in law school.
Well, I've already made my views known what I think of moot courts, but a lot of students use moot courts as a way of avoiding classes or getting attendance, etc. That's one part of it. But when we have our hypotheticals which we create, we give the students the facts from both sides, which are bound to be different. We ask the students to formulate a case theory, and we give the students a case law attached to the hypothetical. The exercise is not to find the law. Exercise is to present what you have, which has been given to you before the court. So it's not what you say, but how you say it. So when we do our exercises, we give the materials. It's a weekend training program in most universities where we teach Saturday, Sunday, 10 to 5, 2 days. Students at the end of those 2 days have more skills than lawyers which have 10 years standing. The lawyers who have 10 years standing may not be able to do the drafting or written standing as these students can do by learning just in 2 days from 10 to 5. In that material is self-contained. They've been given the material, the case law, the instructions, everything. They just need to read and perform. So which is the reason why. But do I also understand that the universities have their limitations because of the Bar Council of India rules, their requirements on moot courts, clinical papers, etc. But there's nothing to change the content of it. This program, which I started in '98, I've been teaching this particular module that I talked about. There are many modules. It's just one example I've given you. But this teaching method of giving a review on a 6 months performance, followed by video review, I started teaching in 1998 in Campus Law Center, but there was no change of the rules. Bar Council India rules remained the same. The university did not have a clue of what's going on. Keeping the same topic, advocacy, case analysis, mediation, the heading remains the same. How I teach it is different. So those of you who would, but again, having said that, even this kind of teaching method is not everybody's cup of tea. Many teachers may not want to put themselves before students. They may make a mistake, they feel. They may get embarrassed. Though I feel there's nothing wrong with it. But if you make a mistake, you say you made a mistake and you move on. So it's so not everybody has the temperament to be able to do it. But from those of you who have the temperament, I would strongly suggest revisit the way you've been teaching law, full stop, regardless of the subject, regardless whether it's substantive, procedural, or clinical, or whatever it is. Revisit the way you've been teaching law. Build on your experiences, build on your skills. But there is a huge amount of areas on which you can add to your existing skills. So that would be my sense or my suggestion to you as far as clinical courses are concerned. Any other question? Well, we can have a break and think about questions and come back to it.
So, you have recorded his speech.
This topic, yes.
So, what did you come to teach? What was the this recorded?
Oh, this is
My name.